Let's go on the record on cause number, Tony, you there? DC 20155249, Pena versus Ortiz. Council, make your appearances.
Juan Marquez for the defendant, Your Honor.
Ramon Rodriguez appearing on behalf of plaintiff Juan Pena.
All right, let's go and proceed.
Your Honor, we brought this motion under the anti-SLAPP statute. I don't know if you've had a chance to review.
I've read it all.
Okay, thank you. I appreciate it. And we feel like there's three bases to allow the dismissal of this case. The easiest one is we feel like the evidence is really, really weak and objectionable. And while we're not shying away from our rights to associate and right to petition, it is at the end of the day an evidentiary motion. And the evidence is just not there for their claims. The response, to my way of seeing it, just repeats the pleadings, and the cases are very clear that if that's not evidence. Repeating the pleadings is not evidence. Never has been, never will be. The second part is the petition, the right to petition. And the third is the right to associate in a partnership that my clients had prior to this dispute and prior to getting married. They bought the property together and they were not married, so they decided to have it as a form of association, which we feel is impinged on by the actions of the plaintiff in this case. And this has already gone through the eviction proceeding and dismissal of the eviction proceeding in favor of the district court. And at this point, my clients are stuck paying a mortgage that has not been paid for a long, that the rental has not been paid on for a year, going on a year. And we feel it's unfair, and we feel based on the evidence that I'm not going to call it frivolous, because the frivolous has nothing to do with an anti-SLAPP. We feel like we have our rights, we were asserting our rights, and we need to have this case.
I guess I don't see how their lawsuit impacts your right, any constitutional right in this case, but particularly the right to associate.
Well, the right to associate is since the ExxonMobil pipeline case is very, very weak. There's very little connection that is necessary. It just needs to be tangential. It doesn't need to actually, it's the ExxonMobil pipeline case where the Dallas District Appeals Court went up to the Supreme Court and was slapped down and says the TCPA does not require that the statement specifically mention health, safety, environmental, or economic concerns, nor does it require more than a tangential relationship to the same. Rather, applicability requires only that the defendant's statements are in connection with issues related to health, safety, environmental, economic, or other identified matters of public concern chosen by the legislature. I just looked it up today, and there's 228 citing opinions and no dissenting opinions, or not even a, it's not even a matter of distinguishing a case. It just simply means that we have, it affects our rights. It affects our right to file for an eviction. It affects our right to communicate between the parties. And it certainly affects our economic interests.
Okay, response?
Your Honor, the response is in line with what I set forth in my response in writing. I tend to agree with the court that I do not see where the constitutional right that's being infringed upon here. Before getting to the evidence, because that's the procedure that's required, right? Let's first figure out whether or not the TCPA applies. We would have to look to see the complaint of communications, even if we were going to go as far as to say there was his right to free speech. Even looking here, right, we're alleging breach of an oral contract. And so we could look at those statements and potentially argue, okay, well, they had a right to free speech. But as the court has pointed out, there's no constitutional protections that are impinged upon here. We're complaining about an oral contract that was made between the parties 10 years ago. Whether or not they filed for eviction today or in the last year has very little relevance on the actual claims of the parties here. Again, breach of an oral contract, which was made back in 2010. So I'm hard pressed to find a place where there are constitutional rights that are being impinged upon. A right to associate, as defined by the statute, has to touch on a matter of public concern. The Supreme Court of Texas in Creative Oil and Gas, 591 Southwest 3rd, and I apologize, let me get the exact pin site for you here. The pin site is at 137, is in considering whether the claims at issue are matters of public concern, the High Court clarified that a matter of public concern for purposes of the TCPA must involve more than a private pecuniary interest of the parties and commonly refers to matters of political, social, or other concern to the community, as opposed to purely private matters, which this is, Your Honor, and this is what plaintiffs have alleged and represented in its response. This is a dispute between what we allege are two parties to a contract, what they allege are a landlord and a tenant, but these are matters of private concern. Nothing here touches or concerns anything that's a matter of public right. So whether they're discussing it as a matter of speech or whether they're trying to associate, as defendant's counsel has framed it, it still doesn't touch upon anything related to matters of public concern. Specifically in Judwin Properties versus Lewis out of the Houston Court of Appeals, that's 615 Southwest 3rd, 388 or 338. I apologize, Your Honor. They were looking at a lease, and so they said, here, the motion to dismiss the opposing parties' counterclaims, arguing statements to third parties regarding the lease between the parties were an exercise of free speech meriting dismissal. The court found that was not the case, that those statements between landlord, or in this case, oil leaser and lessor, were not matters of public concern. So before even getting to the evidence, Your Honor, and looking and going down that road, I first think the court needs to determine whether or not the TCPA applies in this particular case. And I think the court has accurately pointed out that it does not, because there are no constitutional rights here that are being complained of. We're not saying that they didn't have a right to seek eviction, or that they didn't have a right to petition this court for whatever relief it is that they've asked for. We're simply asking that the court adjudicate whether or not there was an oral contract between the parties for the sale of this property.
Okay, the court is going to go ahead and deny this TCPA motion. There's a request, I guess, for attorney's fees based on the fact that this was allegedly a frivolous filing. Is that something you're pursuing, Mr. Rodriguez?
Your Honor, I put that forth because, as I mentioned just now, I was very, very hard pressed to determine where the constitutional rights that were being impinged were requested. I've made what I think is a reasonable request for attorney's fees pursuant to the statute, and provided an affidavit in support of those, which does not include my time in preparation for today's hearing or any of the time spent today.
So I know that the Dallas Court of Appeals has had a number of opinions that have been concerning the TCPA over the last 2 years, where they found the TCPA hasn't applied. Do you know of any decisions that they've had about this issue of, I haven't seen any one way or the other, but I may just not have seen them, where they've analyzed what is frivolous in this context? Like what's the standard for that?
Your Honor, I have not had an opportunity to identify anything from the Dallas Court of Appeals that would.
What about the Supreme Court?
Give me just a second. Trying to go through my research here, and I don't.
May I address the court, Your Honor?
Let him answer that, and then I'll let you address the court.
Thank you.
So let me see. No, none of these that I have in my folder are from the Texas Supreme Court. They're all other sister courts to the Dallas Court of Appeals, but many of them look to the same standards in Rule 13. No basis in law or fact, Your Honor.
Can you give me an example of what another appellate court has done in terms of that it's found that it's frivolous?
No, Your Honor, unfortunately, I don't have any. What I have is the legal analysis that they use, but ultimately each court that I'm looking at here in my research determined that it was not frivolous. But again, given the circumstances here, there not being any actual facts or basis in law for these being considered constitutionally protected rights, that would be the basis in this particular instance.
Okay, response to that, Mr. Marquez?
Your Honor, there is 3 bases on which the court could grant this motion.
So Mr. Marquez, I've already denied it. I don't find this even a close call.
Should I make my objection on the record, though, Your Honor?
Sure. I'll take judicial notice of the file. I really do want to hear you argue that why this isn't frivolous.
This is not frivolous because there's at least 3 bases on which we've requested a dismissal of this case. The other one has been the right to petition, which has not been considered by the court. The third one is the right.
But by your analysis, though, then any case where somebody's challenging eviction would be unless there's something that I'm missing here, any case where someone challenges an eviction would impinge upon someone's right to petition and therefore would be subject to the TCPA. Is that your position?
And that's the law, Your Honor.
That is.
That is the rule.
That is not the law, but
let me. Do you mind my citing a few cases, Your Honor? The right to petition is not limited to matters of public concern, not even constitutionally protected. The Murphy case, a 2016 case out of Tyler, Murphy USA versus Rose. The Tyler Court of Appeals held that TCPA applies even to suits for false imprisonment, malicious prosecution, and negligence. Filing a notice of lis pendens, filing pleadings in a guardianship, and prosecution of those claims falls within the definition of communication in or pertaining to a judicial proceeding within the scope of TCPA. Reporting a crime has been found to qualify as a reporting party's exercise of a right to petition. So that's another basis. And the third basis, Your Honor, I'd like to get to is that 27.005D says that the court shall dismiss a legal action against the moving party if the moving party establishes an affirmative defense. We'd like a dismissal on that basis, Your Honor. I hope that I included that in my filing, and I think I did. But if there's no evidence and this qualifies within that provision, then the petition must be dismissed. It doesn't say if it can be dismissed.
Mr. Mark, okay. So you're not trying to, you're still trying to argue the actual motion. You're not trying to make any argument as to the whether or not it's frivolous. Are you?
It's
I've already denied your motion. So the
Well,
question is there a reasonable basis to bring this? And I guess is that your argument?
Yes, Your Honor. Certainly on the evidence, there is no evidence of the client's, of the other side's case that this was a proceeding, a contract, when they have 3 contracts consecutive that directly dispute what their claims are. So therefore, there is evidence on our part and no evidence on their part. I don't mean to be difficult, but I'm trying to say that,
Yeah.
yes.
Okay. So
So it's
Mr.
not.
Rodriguez,
Yeah.
given that there's no case law really that discusses what is frivolous, or you haven't been able to find a case that shows that, I think this is borderline frivolous, but I don't really want to, kind of go out on a limb here and find that it is frivolous. And so if you want to do any additional briefing, you can, Mr. Rodriguez, but at this point, I'm not going to find that it was frivolous. I do think that it's, but clearly the TCPA does not apply in this situation. So I'm going to go ahead and deny the motion. I don't think that I've seen an order on that, Mr. Rodriguez. If you could go ahead and email my court coordinator and then also e-file this as well, a proposed order. Or did you send one and I haven't seen it?
No, Your Honor, I have not submitted one. I wasn't sure which way the attorney's fees ruling would go. So, but I'll go ahead and send it to Rhonda.
Go ahead and share that with Mr. Marquez before you e-file it and email it to me, and try to get that to me by Monday if you can.
Yes, sir.
Anything else, guys?
Thank you, Your Honor.
Thank
Nothing
you.
further
Yes,
from
have
the
a good day.
Thank you, Your Honor.
So